The court, the finder of fact in the above entitled action, upon my oath, finds the defendant as to count 4 kidnapping victim Melanie Burness guilty. Verdict count 5, attempted sexual assault. The court, the finder of fact in the above entitled action, upon my oath, finds the defendant as to count 5, attempted sexual assault, victim Angela Brasso, guilty. Count 6, attempted sexual assault. The court, the finder of fact in the above entitled action, upon my oath, finds the defendant as to count 6, attempted sexual assault, victim Melanie Burness, guilty. All right, counsel, I'm up for positions on the next step and when we start the next step.
Well, I assume, because we've not discussed any instructions for the aggravation phase, we need to do that.
We do.
I'm prepared to argue it whenever.
I think we need to talk about some law that I discovered regarding count 6 and aggravation phase. Do you want to talk about that now?
Sure.
Okay. Mr. Parker, you good with that?
Happy to, Judge.
Okay.
And we're prepared to address all that information as well.
All right. So, as the state amended the notice of aggravating factors for the death penalty, the law changed between Ms. Brasso's murder and Ms. Burness's murder, as you know. In the state's amended notice, the F2 regarding Angela Brasso, and this is what you filed on June 8th of 2020. You said F2, the defendant has been or was previously convicted of a felony in the United States involving the use or threat of violence on another person, and then the state added whether preparatory or completed. The statute did not include that language, whether preparatory or completed, in 1991, 1992. There's case law that talks specifically about attempted first-degree murder, and if it can be completed without the use or threat of violence, you can't use it as an F2.
I understand.
Okay. So the court's concern, because we're cross-applying, but the court's concern is I don't think you can use count 6 as an F2 factor for count 1, if that made sense. Now, the wrinkle is you allege dangerous. And I couldn't find any case law that specifically talked about that.
I think that allegation may have been outside of the statutory language at that time as well, if we're talking about the same use of dangerousness. But I think the argument that the court is raising, or the position with respect to the law, applies also to count 4, and whether that may be used against count 1 as an F2 aggravating circumstance.
Whether kidnap can occur without the use or threat of violence?
Just by the statutory definition, correct.
Well, and then you have the kicker that you can't double count. Like I can use count 2 to find the F2, but the trier of fact can't then use it as a double aggravator. That makes sense.
Well, the attempted sexual the attempted sexual assaults are, you have found them to be guilty. They're dangerous.
Well, not yet they're not, because we didn't include that in the,
Correct. We still have to do that.
right.
We're not there yet.
Right.
And I would agree that absent that you could commit attempted sexual assault without it necessarily being a crime of violence,
Right.
which is what was required.
Right.
But I would want to think it was, I can't remember the name of the defendant right now, McCrae. State versus McCrae was a situation where there was a sexual assault committed that was alleged to be an F2 at a time when it had to be a crime involving violence, but it was found to be dangerous. And the Arizona Supreme Court found that qualified. So I don't know if that's where you're going, but
I would add that I think if we take a look at capital case instruction 1.6A, A1,
So, sorry, pause. Check your emails. I just emailed you draft one. Okay, so we can look at that as well. But let me get my Araji's open. Sorry, Mr. Parker, go ahead.
capital case instruction 1.6A2, which is referenced in the Rajis with respect to offenses occurring before July 17th of 1993, addresses the situation with respect to F2s that may have been considered prior to that date. And there's some information in the comment that I think would help guide this discussion. The information does not reference using dangerousness as an allegation to allow the state to argue that based on a separate allegation, they could therefore satisfy the requirement of violence as it's defined at that time to meet the circumstances of the F2. What this really says is you have to look at the circumstances of the actual definition.
Right, and that's what the case law says, yeah.
Right.
as I said, the court needs to read State versus McCray.
MC,
McCray. I think there's two Cs. Yeah, two Cs.
the 2008? Maybe, sound right?
That's about right. It was the original murder happened, I think, in 1979, maybe. So I can't remember the exact year that it happened. But the trial didn't occur until, that sounds about right.
All right, the site for, basically, Ms. D's, 218 Arizona 252.
Yeah, the crime actually, I guess, occurred in 87, but we didn't go to trial for, wasn't solved for a number of years.
Let's see. Okay. So McCrae's prior conviction was for a sexual assault with a dangerous enhancement. And McCrae says for the purposes of applying the F2 factor, court should consider the fact that a prior conviction included an enhancement for dangerousness. The dangerous nature of the offense must be charged and either be admitted by the defendant or found by the trier of fact. The allegation of dangerous, in effect, adds to the underlying offense as an element that subjects the defendant to increased penalties. I think that answers the question.
It should.
It does for the court. But I know you're just getting this as well, so. Do you all want to take a break and look at what I emailed you, and I can come back instead of everybody sitting here staring at me?
That sounds good, Your Honor, thank you.
Okay.
Appreciate that, Judge, thank
All
you.
right. 2:30 enough?
Should be.
Certainly, we have quite a bit to discuss. I think that gives us enough time to at least review this case and prepare some additional information for the court if needed.
Okay. I'll be back at 2:30.
Yeah, that works. Let me just